Act 2 will have in the second half. Do one thing, give the note. There's a system in advance, you can do it. There's a procedure, it has been notified. You give it to us, no need to make a mention. Give it. Okay. Give the application. Yes. Not only in the code file, you have to also do it in the service copy in others for all. Give it to all. Okay. Put your initials. By the time, if you take up, if time is there, we'll take up. Let us see. You do it immediately. Yes, madam. Not on Friday. Court will rise early on that day. We'll have it on 22nd. 30. Let it on the prayer. 2 weeks on it to be fixed by the test. To file to be filed by the department in item 40 or item 15. Mr. Sistri, look into it. Okay. On the prayer of the council for the parties, release this matter on a date to be fixed after 2 weeks later on a date to be fixed by the registry. In the meanwhile, the respondent, the elementary education department, shall file their affidavits in the matter without fail. Okay. Matter did not reach. Okay, on 21st. Wednesday, 22nd. Yes. 23rd. 22nd, it is Wednesday, let it be on 23rd. It's for motion or for orders or what? For motion. Then on 22nd. You are there in 7 also. On the prayer of MSKDV, adjourned for 4 weeks on a date to be fixed by the registry. Yes. Mr. Nayak, anything there? After BU vacation. Give the number, please. WPC number. Give the date. Mr. Sisti, see, basically what happens, court passes in an order on various considerations. And it's not that in one-way traffic. After reasonable consideration following the provisions of law, the normally court passes an order. What else happens, there are different decisions in different aspects. And at times you will see the all decisions are not alike. Honorable Apex Court has laid down the law, our court have already settled up positions. But what you should have is that you should have in your team, you must have those judgments in your hand. While disposing of the matters, at least you must be able to place those judgments in the orders of the court. Right. Here is a case. The person in the governing body of the college or the managing committee of the school has allowed the petitioner to work as an honorary teacher in a provincial high school. Law is well settled. Even then, there is a direction for payment of salary. Salary because the person has rendered service. Person has rendered service and it was knowledge, it was in the knowledge of the department. In spite of that, allowed the petitioner to continue in service. So definitely when you know about it, and the petitioner rendered his service, he is entitled for something, whether it will be salary or it will be honorarium. Side by side, the judgments are, if the concerned person has accepted the conditions of appointment, question of payment of salary doesn't arise because he was appointed on honorarium basis. Who will pay? The managing committee. That is why, if you read the judgments of the Apex Court and judgment passed by our court, there are many cases when it was placed before the court after the judgments rendered by the Honorable Apex Court in the case of Andhra Pradesh. Our High Court has allowed. First of all, the concerned person who has been appointed honorarily by the managing committee of a school or a college or whatever in a provincialized institution, the concerned person has to file a civil suit. Managing committee. Whatever is payment, they should be made. But the government, not from the public exchequer, because he was not holding any public post. He has served at the behest of the managing committee of the school. Those judgments, he should bring it to the notice of the court when these orders are passed. But what we have noticed, as soon as there is a question of payment of salary, you feel happy. Somebody is willingly to pay. After all, these are public exchequer. How can you decide? And these contempt things are very much, definitely, it's a violation of the order of the court, non-compliant. But what is the law laid down in the contempt cases? If something is not compliable, what is the question of contempt? And all these things are not placed before the court when these orders are passed. These things are happening. See, every time court will not remember everything, right? It is a duty of, that is why you are the court officers. That is why you are court officers. Things are very important, right? You should have those things in your hand. Immediately, you should just click and get it. While in the other side, I used to take help of Ujjal Goswami and A. Deka. That's why they are having all the storehouse of all these things, right? It is very important. It is not here because not reflected in this order. Got it. Registry shall reflect this matter, list this matter on 21st of April, reflecting the name of Standing Council Elementary. Petitioner shall serve an extra copy of this contempt petition to Mr. SMP Standing Council, Department of School Education. Yes, Mr. Laskar. Mr. Sisti, while considering all these aspects, you also try to find out how many matters are there at district level suspended by the district authorities without having getting the information to the directorate. If the matters are pending for more than 3 months without anything, you should take care of. These matters should not come to the court, right? This is a law settled. So if they have failed to issue any show cause notice, then they should take immediate action. And that's why sometimes you will see the district authorities, their high-handedness in the district authorities considering all these questions, should take action against all these people. Similarly. Okay. So I have 2 copies on Mr. Sisti. Higher education, Mr. Das or someone is here. Okay, reflecting the name of Standing Council Higher Education on 28. So uh, 2 extra copies to Mr. K. Gogoi, Standing Council Higher Education. Elementary education, same day. Serve 2 copies on Mr. Sisti. Mr. Sisti, try to get the instructions. We have given you sufficient time. Yes, Mr. Decker, what do you want to say? Hmm. Yes. Hmm. No, that we have seen. What? Hmm. Page. Hmm. 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 Heard Mr. P.K. Decker, counsel appearing for the petitioner, and Mr. Vikasik, standing counsel, Department of School Education, for the respondent numbers 1, 2, 3. Mr. B. Gogo, standing counsel, SSA, for the respondent number 4. Mr. B. G. Bokulial, Government Advocate Assam, for the respondent number 5. Petitioner has had the requisite qualification to be appointed as an assistant teacher in an upper primary school in the state. While the Biraj Mohan Kumudini Dr. ME School the Gauripur Education Block of Dhuburi District during its fancy stage, appointed the petitioner as an assistant teacher to teach Assamese to the students of the same school, and accordingly petitioner joined her said service on 22/03/2004. It is submitted by the petitioner that while the services of the teaching and non-teaching staff of the said school was taken up for consideration for provincialization, under the provisions of the Pura 2017 Act as amended. The District Scrutiny Committee did not consider her case in, in okay. The District Scrutiny Committee, considering the enrollment, do recommended her name, but the state level scrutiny committee did not consider her name for provincialization, and recommended only 3 teachers of the said upper primary school, namely the response number 6, sorry, and one Ravi Chandranath and another Mehboob Alam. Being aggrieved, petitioner preferred a writ petition being WPC number 4670/2021 that was disposed of on 16/9/2021. Please take your seat. Directing the Director of Elementary Education Assam to examine the aspect as to whether the said school has the number of students between 91 to 120, and if yes, as to whether one additional post of teacher can be provincialized over and above the 3 teachers who were provincialized as provided under Section 3(1) Din Bracket Roman 11 of the said 2017 Act. By the said order, dated 16/9/2021, passed in WPC number such and such, the court further observed that if during the said process of examination, the director arrives at his conclusion, at its conclusion, that the school is entitled to one additional post of teacher, he would further examine as to which teacher of the school is to be provincialized against the additional post, and in doing so, the case of the petitioner shall also be given a due consideration. In pursuance of the said order dated 16/9/2021, passed in WPC number such and such, the Director of Elementary Education Assam, after due consideration, by the order dated 19/11/2022, rejected the claim of the petitioner for provincialization of her service, as it was found that said Biraj Mohan Kumudini Dr. School had less than 105 enrollment to have more than 3 teachers as per the provisions of the said 2017 Act, and for which the state level scrutiny committee as well as the joint committee could not recommend the name of the petitioner for provincial of her service, though recommended by the district scrutiny committee. Though petitioner filed a contempt case, being contempt case C604/2022, for not complying the order dated 16/9/2021, passed in WPC number such and such, but by order dated 23/01/2023, the court closed the said contempt proceeding, as the respondent authorities, I, the Director of Elementary Education Assam, on 19/11/2022, passed the order in said WPC in compliance of the said order dated passed in WPC. However, while closing down the such and such, the court granted liberty to the petitioner to challenge the said order, if so agreed by the same. Petitioner has placed before the court that while the district scrutiny committee considered the case of the petitioner and recommended her name for provincialization, it found that the enrollment in the year 2014, 2015, and 2016 in that school naam to cooperative is above at the average of 105.26, and accordingly recommended the name of the petitioner for provincial level service, considering such enrollment of students in the said schools in those 3 years. The petitioner has also placed before the court the dice of 2018-19 of having 107 numbers of enrollment of boys and girls in the said school, considering the 11 years of 2014, 15, 16, as well as 18, 19, having more than 105 students, 5 enrollments in the said school, petitioner is entitled for provincialization as provided in the said 2017 Act. Section 3(1) within bracket 11 already provided that in case of venture upper primary school, there shall be a minimum 3 teachers or tutors, at least 1 teacher each for A, science and mathematics, B, social studies, and C, languages. Provided that for additional post, it shall be considered in accordance with the norms and standard stipulated in the schedule under section 19 and 25 of the Right of Children and Free and Compulsory Education Act 2009. Section 3(1) Roman 12, small Roman 12, specifically provides that the enrollment shall be verified with the data as per DICE code 2009-10 or before, as available in the records of the National University of Educational Planning and Administration, New Delhi. And there shall be physical verification of students and checking of records of attendance of students of last 3 years. In the case in hand, the petitioner failed to place any such numbers of enrollment in said Kumudini such and such high school, as per the data recorded in DICE code 2009-10 and before, for such additional teacher in said Kumudini such and school at the relevant point of time. Considering the above, the court is of the view that the impugn order dated under number EPD oblique H oblique 254 oblique 2022 oblique 63 dated 19/11/22 issued by the Director of Elementary Education Assam doesn't call for any interference. Accordingly, this writ petition being devoid of merit stands dismissed. Mr. Why for this reason petitioner should come to court? Tell us. Why for this reason? You have regularized his suspension period. Why are not paying his salary? How much salary he will get and how much amount he will pay to his lawyer? What is the reason? Tell us. Please come to page number 16. Then, this is in December 2021. His period of suspension treated in all duty for all purpose. Now, this order was also written to the headmaster of the school, who is the drawing and disbursing officer. So, for this, do you think any order of the court is required, or it's just administrative order could be sufficient from your part? See, probably you are aware, if for certain period of time, if it's not a small duration, from August 2016 to February 2021, 17, 18, 19, 20, 4 years, right? And 4.5 years. You need to have the approval from the finance. Mr. Chaliha, if a person is not paid his salary during his suspension period and we reinstate in service, what do you follow? What procedure do you follow when a person is reinstated in service as considering his past service as on duty? What do you do normally when a person is placed under suspension? You have that particular salary already given to that person because that account, no release may not be there because drawing and disbursing officer will not make any bill for that. But what do you do? No, just tell us one thing. Say, for our understanding, for 10 teachers, you are paying them salary 10 rupees per month and 100 rupees is their salary. Somebody has been suspended. Though 100 rupees are already sanctioned for every month, not disbursed because been suspension. So what do you do if that money is not claimed for 4 years or 5 years? Because during that period, only the substance and surveillance are paid. Initially 50 rupees, right? 10 rupees, it means 5 rupees. And then it will be 7.5 rupees. What do you do? So these balance amount are not disbursed. It remains with the department or it is returned to the finance department. Or it automatically goes back if it could not be disbursed during that financial year. So it is the administrative department should place the relevant budget. No, no, non-royal will definitely by treasury officer will be given. Has to be given.
The treasury officer has to ask from the administrative department. Treasury officer cannot issue the contract because he is not aware.
Okay. Okay. So according to you, it is the drawing and disbursing officer who will issue the non-royal certificate, not the treasury officer.
Of my non-royal certificate is issued by the DPO and the DPO forwards
Then see at page number 19.
record for the non-royal certificate for the following amount relating to any salary for the period shown there in respect of below mentioned number of subject know-how is not available in the treasury office. Since there is no system and procedure, the treasury maintain the non-roll records of the
Okay.
treasury of your individual bank.
Then how come the amount?
But should maybe they have communicated that the non-roll certificate on the basis of the non-roll certificate only the treasury officer can proceed.
Hmm. Now he was the head teacher. In that case, will be the DDO when the head teacher itself is under suspension. Will be the DDO, Mr. Kaushik, Mr. Vikas, tell us. Now, Mr. Salihya, according to you, what is the procedure to be followed?
Non-roll certificate is a requisite as per law in order for the treasury officer to proceed. I sometimes day after tomorrow, Lordship, I can at least clarify the stand of the treasury officer. But without the non-roll certificate, the treasury officer is not.
Or it needs a verification from the treasury officer that this amount was not drawn because the concerned incumbent who is placed under suspension, he will get only subsistence allowance. So he will not get the regular salary. So in that circumstances, whether a certificate from the treasury officer is sufficient to have the claim of arrear salary.
Maybe there is the treasury officer is in dark regarding what is the process and what. And there is always some shortfall in the documents part, which the treasury officer communicates the department, but it stays in the.
Where is the suspension order? Likha. Heard Mr. M. Ali, counsel appearing for the petitioner, and Mr. Vikas, standing counsel, Department of School Education, for the respondent numbers 1, 2, 3, as well as 5 and 6. Also heard Mr. H. Chaliha, standing counsel, Finance Department, for the respondent number 4. Mr. I think there was a circular earlier, all the, in terms of the direction of the Honorable, in terms of this central government, from the right to education, I think so. The headmaster of an ME school should be a graduate. ME, this is ME, Muktab. Muktab is LP school, okay. Okay. Petitioner is the headmaster of Uttar Dhing Gaon Balika Muktab School. Renamed as Uttar Dhing Gaon Balika Lower Primary School in the Julia Education Block of District Nagaon. Service of the petitioner was provincialized with effect from 01/01/2013 under the provisions of 2011 as amended. Pursuant to the order dated 14/05/2013 issued by the Director of Elementary Education, Assam. By an order dated 09/08/2016, the Deputy Inspector of Schools, Nagaon, suspended the service of the petitioner because of his unauthorized absence and for not providing midday meal to the student of the said school from 01/08/2016 till the issuance of the said order, suspension order. The said order will he placed the petitioner suspension liquidation under liquor. Rule 6 within bracket 1 within bracket small a of the Assam Service within bracket Discipline Appeal Rules 1964 with immediate effect, enabling him to draw the subsistence allowance. After 4.5 years, after more than 5 years, 1 month, the Deputy Inspector of Schools, Nagaon, by an order dated 03/09/2021, reinstated the petitioner in service in his original place of posting with immediate effect. By a subsequent order dated 14/12/2021, the Deputy Inspector of Schools, Nagaon, passed an order. Order to लिखी sir. Okay. Treated the period of suspension of the petitioner as on duty for all purpose. as the petitioner was not paid his regular salary from 01/08/2016 to 28/02/2021, as he was under suspension and received only subsistence allowance during the said period, comma, after his successful said suspension being treated as on duty for all purpose by the said order dated 14/12/2021, the petitioner claimed as an amount of rupees 5,63,589 as his arrear salary, which is yet to be paid. Being aggrieved, petitioner has preferred this writ petition. The petitioner placed before the court that though the block elementary education officer wrote to the treasury officer Nagaon for issuance of the non-royal certificate for an amount of rupees 563,589 by the petitioner for the period from 01/08/2016 to 28/02/2021, but the treasury officer Nagaon, by its communication dated 04/02/2023, refused to issue any such non-royal certificate in favor of the petitioner relating to his arrear salary of rupees such and such, stating that no such records are available in the said treasury office with regard to non-royal of such amount by the petitioner, as there is no system and procedure in the treasury to maintain of such non-royal records of any kind of payment. On being inquired, Mr. Chaliha, Standing Counsel, Finance Department, for the response number 4, submitted that if some amounts are not drawn during a particular financial year, including the salary, the concerned administrative department refunds the said amount back to the finance department, right? For the purpose of payment of any such arrear salary, it is the concerned drawing and disbursing officer within bracket DDO have to issue necessary certificate of non-releasing such non-royal of such amount to whom? To the finance department.
DO will issue the non-royal certificate to DO.
To the treasury officer, and it is not the treasury officer who is required to issue such non-royal certificate. On the next date fixed, the finance department of the state shall apprise the court the correct procedure to be followed as per the rules, financial rules, to draw such the procedure to be followed for payment of arrear salary if someone's services is regularized, placing him under suspension for a relevant period of time, as well as the procedure for issuance of such non-royal certificate by the authority. List on when Mr. Saliga by 38/30. Petitioner shall serve 2 extra copies to Mr. Bikosik as well as Mr. It is common 30. Let's take the procedural case here. Just a minute. No. Yes. ये जो फालतू लेसन है सुना है ये tidak boleh nak boleh nana terus tu kalau dari pada no community protection Okay, I think. কোনটা record করা? নাই। July 10 July না হয় section of the Mr. Buragoy, take your seat. Okay. Yes.
Core contention was regarding college. It was basically the college was very two important questions was for and board has directed respondent authorities by examining on two important questions. That questions are page 72, wherein the authorities were asked to decide whether the institution had applied for recognition within the extended time period.
Get hold of Mr. Alam.
And secondly, my lord, regarding whether this institution was in existence prior to the coming into force of this act, my lord.
You have not given notice to Mr. Alam.
No notice.
Why?
They are party, my lord.
They are a party. Why
Yes,
have not given notice?
Copy of that, sir.
You have not served notice on him.
Their name
Oh,
is
oh.
not in the public.
Name is also not given.
No, no.
I'm
So,
sorry, my lord. Maybe there must be a mistake on my part, my lord.
Yes, then what happened?
Yes, my lord. So the exercise was directed to be undertaken by the government to decide on the two questions: whether this institution was in existence prior to the act coming into force in the year 1995, and second point was whether this institution is applied before 18/8/1987. So, my lord, what the government did, my lord, and after that, my lord, the current writ petitioner also made a challenge to the appointment of private respondent number 6, which your lordship will find at page number 75, my lord. My earlier round of litigation, page 75, my lord. Here, my lord, similar contentions was raised by me, and the court, my lord, directed, my lord, the petitioner and the petitioner in the other case to appear before the additional secretary, education department, secondary, my lord, and to conduct a hearing on these issues that we raised. And the my lord, the questions that was placed before the honorable court to answer those two questions, my lord. Kindly, my lord, may come to page 78.
Mr. Brahma, just a minute.
Yes, my lord.
Take this matter after some time.
My lord. My lord, may call the matter after some time.
After a few.
Oh, okay, ma'am. I'm obliged.
May present. In this case, my
So now
lord.
you're on the other side of education.
Yes, Lord.
Yes, tell us what's the matter about.
Here, my lord, the deputy commissioner role in the matter of my lord, creation of a managing committee is under challenge, my lord. Usurpation of power by the deputy commissioner, who has no role in the matter of non-government educational institution, is the director of education, my lord, who is entrusted in case of any anomaly or any inquiry which is to be done, it is to be done by the director. The deputy commissioner has no role. Now, suddenly in this matter, my lord, the deputy commissioners holds a meeting and forms a managing committee, while the duly constituted managing committee is declared to be, my lord,
Which school it is?
it is Silchar Collegiate School, my lord. It is a non-government education institution. And my lord, what has happened? He has appointed one executive magistrate to handle the financial matters of the school. Meaning, under the provisions of the Act, my lord, neither the deputy commissioner nor the executive magistrate has any role in these matters. And there was no specific allegation regarding mishandling of finances by the managing committee of the school. In the absence of any such allegation, deputy commissioner could not have hold this meeting and declared this duly constituted managing committee as illegal. Section 12, my lord, is the Constitution of Managing Committee.
Has it been registered?
Yes,
The
my lord.
government as a non-government institution?
Uh,
Has it been registered or not?
That is not disclosed, Professor.
That, of course, that
That is
information.
prime.
That is
Needs to
not
be
disclosed.
registered.
I am not making a statement to that effect, my lord.
এখন সাইলেন্ট হয়েছে।
What will happen if you don't extend the website?
It is affiliated to whom?
This Malad under the state
Seva or
board.
CBSE?
Malad, Shiva Malad.
Yes, Mr. Sister, there is no such procedure in the rules.
Only thing that the lawsuit is, section 30, removal of any difficulty lawsuits. Under this provision, if any difficulty arises in giving effect to any provision of this act, the matter shall be referred to the act and the matter shall be referred to the state government whose decision thereon shall be final. So here the managing committee has been lawsuit, DC has taken. But that
What is the
not there.
authority?
There's no
For the
authority.
intervention of the deputy commissioner.
There's no such authority in this act.
Yes, if it is within the district administration or if it is in the area of such municipality, that is something different.
Yes, otherwise there is a provision to appeal if the director has passed any other
Director is not passing.
adverse order lawsuit. Then they may file appeal within 30 days.
This issue also cropped up in one of the matter, with particular mosque in the district of Dhubri. The district administration intervened, it was barred. But there's an order, that's why the jurisdiction was given to the deputy commissioner. But neither the 2006 Act or the 2007 rules provides for any
Yes.
such.
Intervention by the deputy. No lawsuits. So may I put the matter may be referred to the government lawsuits?
Let us see. RMS, P. Chakraborty, counsel appearing for the petition. And Mr. Representative Sister Standing Counsel.
And for
Department
one
of
only.
Education for the response number 1. Also heard. Mr. G. Gopal, Government Education for the response number 2. Petitioner was the Arsal member of the managing committee of Silchar Collegiate School, was nominated to represent the Guardian Society of the said school. It is stated that the Silchar Collegiate School, though a non-government educational institution and amenable to the jurisdiction of the Assam Non-Government Educational Institution Regulation and Management Act of 2006, as well as the Assam Non-Government Education Institutions within bracket Regulation and Management bracket was rules 2007. And the society under the Registered Act. The Deputy Commissioner Kachar on 11/10/2022 interfered with the constitution of the Managing Committee of the said non-government education institution, Silchar College, in violation of the provisions of the Section 12 of the said 2006 Act. It is submitted that the Deputy Commissioner has no such jurisdiction and authority to interfere with constitution of any such managing committee of a non-governmental education institution. Hence this petition by the petitioner for setting aside and quash the minutes of the meeting dated 11/10/2022 regarding constitution of a new managing committee of such and such being interfered by the Deputy Commissioner Kachar. That is the 2006 Act and the rules 2007. 2006 Act and 2007 rules. List on 31st of March, and on the said date, the Deputy Commissioner Kachar Silchar, respondent number 2, shall apprise the court under what authority and jurisdiction it exercise its power in constituting a managing committee of Silchar Collegiate School, a non-government education institution in the district of Kachar. Petitioner shall serve such and such. The other prayers of the petitioner. Including the interim prayers of the petitioner shall be considered on the next date fixed on such instruction, on such submission of report of the Deputy Commissioner Kachar. Petitioner shall serve 2 extra copies of this thing, Mr. At this stage, let the Deputy Commissioner.
Yes, yes.
Yes, Mr. Bravo. Mr. Sisti.
Yes, Your Honor.
Mr. Alam.
Mr. Alam is here, madam.
Recently, you have passed an order, you remember, that with regard to that Hailakandi B.Ed College, which is renamed as Dr. Shashi Bhushan.
Yes, madam.
This court passed an order where the record was very quick because one of the ladies, I forgot her name, the petitioner, she filed an additional affidavit regarding the approval given by the Assam University. And in fact, the question here in this present petition is the establishment of Hailakandi B.Ed College. Whether on that particular date when this NCT Act came into force, that particular Hailakandi B.Ed College was in force or not, was in established or not. But formed that particular affidavit where we have dismissed that petition. I'm not getting it, that's why we've been finding it out. That in the additional affidavit, the petitioner has annexed the affiliation because it was a newly established B.Ed college.
My lord,
It was found that after the appointed date,
my lord,
the Assam University granted affiliation
my lord,
to start the B.Ed college.
my lord.
Just that is why we have taken the matter little lately to find out, because in that additional affidavit, it is very clear. আপনি আসলে কোন আসলে পড়লেন? আসলে মহিলা এগারোটি কেস আছে। It's a from Hailakandi, from Borakali.
Pamalendu Devnath's case, my lord, that was
Huh?
pending, my lord. Pamalendu Devnath's case, my lord. There is a series of matters, my lord, 3 or 4 matters, my lord, from that they are listed, my lord. And last part, my lord. In the last part, and your lordship passed a detailed order regarding this Hailakandi B.Ed college, my lord.
That's what I still remember, because I have
Yes, my lord, I remembered, my lord, and I will.
in that particular affidavit, the petitioner herself placed before the court in an additional affidavit, and on
Yes,
which
ma'am.
state the Assam University has granted affiliation,
Yes, my lord.
and that was the after the cutoff date.
Yes, my lord.
Do you have the number? That or any whatever?
Pamalendu.
There are someone challenged her appointment. Because recently you appeared in that matter.
Yes, my lord, I am appearing, my lord, that in both the 3 petitions, my lord, and one of the petitions regarding the Hailakandi B.Ed college, my lord.
That's sorry, but do you have by chance? Recently, it happened sometimes in February probably.
The last month, my lord.
Order is yet to be. I remember dictating the order. That's why I'm saying. It's very clear. It was the after the coming of the force of the NCTA.
My lord, I will provide that number, my lord, after some time. my lord.
Kindly, can you give it to us today itself,
Yes, my lord.
so that we can take it up this matter tomorrow?
My lord.
Because
I-
the additional affidavit they brought into force, the
My lord.
date of affiliation given by the Assam University.
I understand, my lord. On that day, they refer the additional affidavit, my lord. I will provide the number, my lord, the petition number, my lord.
Was it a review?
The petition, my lord.
Review or repetition?
WBC, my lord.
5 to 5 it has.
5 to 5.
You appeared in that matter?
No,
Mr. Eskedas was appearing in that case. That may be 5258 of 2022, disposed of on 16th of
No,
February.
no, that not that matter, my lord. Yeah, but that is regarding 2018 matter.
Okay, okay.
5-2?
5258. That also pertains to B.Ed degree.
No, that's very specific affidavit been placed by the one of the respondent probably.
These are the pending matter, my lord. And matter is listed in this month, my lord, either 31st of March, possibly, my lord. I will give them detail.
Suggestion 5-5. Five to 5-8 of which year, Mr.
22, my lord.
It's an old matter.
This is old matter, my
Probably in
lord.
admission stage. No? It is. মনত আছে নেকি? Oh. 21st, So unification day one. No, that's right. The order is not out. It was last hard on 21st of February. That's why I dictated the order. Remember this fact. So we get it.
Yeah. Uh, 4480/2017, my lord.
In one case, association is also there. That's
Yes, my lord. 4480.
Of 2000.
in WPC 4291/2017, Vision Nath Association is involved. One is Vivekananda College of Education. So we'll have it tomorrow.
My lord.
Okay, that I have seen that. I have
My lord.
because while considering that matter,
My lord.
I have seen that particular affidavit. Mr. Burogai, serving a
I'll
copy.
serve him a copy.
We'll have it tomorrow, Mr.
My lord.
Alam.
I'm highly obliged, my lord. Deeply obliged.
This is tomorrow. Do like list tomorrow. Showing the name of standing council and city. What is number 5? I think.
Yes, my lord. 5. Obliged, my lord. Deeply obliged. Obliged.
In this case, nothing notice should go at first notice.
Yes.
May I please as a lordship? I have an interim prayer, my lord. Otherwise,
What is the amalgamation?
my lord, the order of amalgamation, my lord, may be pleased to find at page 149.
The 27/5/2022.
That is correct, my lord. We are agreed by the clause 9 at page 150, my lord. May I, not page
Where is
100,
the
my lord. Okay, to keep it.
So misplaced in copy and আর ইমান ডাঙৰ সেকশনটো চকুত পৰি থাকিব লাগে
Mr. Alam left?
আলম গ'লে নেকি এই সাগৰ
Principal.
Mr. Alam,
My lord.
that is in WPC number 7823/2019. Muchabir Ali. Probably it was withdrawn later on 13th of July. This is the order the court pass. This court pass after verification of the records. Some cases also pending, no doubt, but there is there. After the coming into the force of the NCT Act in 1996, 1997, it applied for a affiliation from the Assam University, and Assam University granted affiliation for the academic session 96, 97. After the coming into the force of it is very much there in the order. If you read it, you will know. Yes, Mr. Bhuya, where
My
is
lord,
that order of,
my lord, we are
amalgamation?
agree.
Where is it order of amalgamation?
My lord, at page 149, an order dated, my lord, 27/5/2022. Now, my lord, admittedly, my lord, this order of amalgamation had been issued in view of the, my lord, the recent policy decision of the state as regards, my lord, the Shiksha Kshetra scheme. And my lord, in the very
Where is
beginning,
that
my lord,
mentioned that it has been amalgamated under Shiksha Kshetra?
my lord, it has not been the, yes, my lord, that,
But Mr. Sisti, this
My-
Shiksha Kshetra scheme was also was notified in the Gazette.
Yes.
You have kept earlier given us a place. So
my lord, I have annexed the.
no, there is a Gazette notification regarding this.
At
Three
page-
notifications have been issued. The last one was notified in the Gazette.
My lord, and my lord, I have annexed the 2021 at page, my lord, 125. We are not against the amalgamation, basically, my lord. We are against that the Wakaf property, my lord, in which
Just-
this,
just-
my lord, in which this
We'll come to
institute, my lord.
Gazette notification is on us also.
My lord, the very property, my lord, in which this institution was established and created is, my lord, is a property.
Kali Kumphan School of Water Quality, Asina High School, Kali Kumphan School, A and B. A and B Kali schools. Kali A school, A and school B as an education B as an. No, 45 is 45 to 40 is. 45 college, different school amalgamation.
It has been gazette notified, my lord, recently, my lord. This,
No, that's,
yes, yes, my
that's
lord.
I
I have-
remember, that's why.
I have, it is also uploaded in the web also, my lord. So, my lord, in this petition, my lord, our basic grievance is that government cannot acquire or take away the movable as well as the immovable property of a Wakaf, my lord, which has been created by the Wakafi by way of a, my lord, Wakaf deed. And, my lord, the present institution, my lord, that Asimia Senior Madrasa, my lord, is a creation of, my lord, by the that process of law, and which is protected under the Wakaf Act 1913 and which has been recently amended in the year 1995, my lord. So, my lord, this very clause, which I have brought your lordship's time notice, my lord, at page 150.
No, whether the school is provincialized or not.
Yes, yes, the school was provincialized, but the property has never been acquired by the government, my lord. If my lord may be pleased to take up section,
Two things.
section 10, my lord, of the 1995 Act, my lord. Well, it is very clear, my lord. This property has never been acquired by the government. Only the staffs has been provincialized, my lord. And, my lord, this institution has been held to be a minority institution, my lord, by the honorable division bench of this honorable court. My lordship is well aware, my lord, regarding that judgment when these madrasas had been converted into the schools, my lord, which had been put into challenge. And this honorable court was very clear that by the expenses of the government, my lord, no religious education can be imparted. That's why, my lord, this has been treated as to be the religious institutions, my lord, prior to revocation of the same and transformation of these institutions. If my lord may be pleased to take up the 1995 Act for a moment, my lord, at phase.
But the honorable division bench has already approved the such provincialization and
No,
taking over.
my lord,
the-
my lord, we are not against the provincialization or any of the action of the government. Now, my lord, when
Only
we,
the taking away the property.
my lord, we are basically agreed that our property wherein this, my lord, particular institution was established for a definite purpose for the religious education, my lord, which has been given under the protection of Article 25, 26, and 29 of the Constitution, my lord. Government by which, my lord, they cannot take up the, my lord, or acquire the property, my lord. अरे report for 95 F1. Oh, that was a 392. My lord, may I be permitted to draw? My lord.
This order of amalgamation was issued when on
27/5/2022, but the property, my lord, has not yet been, my lord. It has been shown, my lord, that pursuant to the High Court order, my lord, this honorable court's order, it has been issued, but that is also not correct, my lord.
What is the order first?
My lord,
What was the order cost?
Order of the amalgamation, my
No,
lord.
no, 20th of April 2020, WPC 130.
Yes, my lord, I have annexed, my lord.
Page 147 Lordship.
146 is the relevant, my lord, 147.
The order clearly stated that Asimia title matters is running with a single teacher Lordship. And it is also that there is no bar for amalgamation of the state school Lordship that is given.
My lord, the relevant part, my lord, may be pleased to find at page 147, it is said, my lord, that it is made clear that pendency of the writ petition shall not be a bar for the respondent authorities to amalgamate Asimia High School with the Asimia Higher Secondary School if it is permissible in terms of the office memorandum dated 3/8/2021.
And
My lord, it is not the direction or mandamus has been given that you go and amalgamate. This honorable court has held that if it is permissible under the guideline, my lord, then only they can
No,
go.
no, this is, no, it's not the reason.
My lord, this is the, my lord, observation of this honorable court, my lord, at page 147 and 148.
And prior to that, Lordship, there's another observation that the Asimia title matters is running with a single teacher Lordship, who is the petitioner itself.
That is.
And the very exam of the school is at stake if the urgent action is not taken by the respondent authorities.
Basically, my lord, we are not opposing or, my lord, we are not, my lord.
And in
against
office
the-
memorandum, Lordship,
Against the amalgamation, my lord.
okay,
Our, my lord,
we'll have it now. Don't worry.
my lord.
It's coming up. Don't take care of.
Right. Doesn't. So, my lord, our basic grievance and, my lord, the which we are.
and Lordship in the office memorandum of 3rd of August 2021, Lordship clause 7, subclause 4, there is a provision for Lordship that movable and immovable property of the school shall be vested in the name of amalgamated school, that is the base school. The
That's
provision
why-
is there, Lordship.
That's why it is not permissible in, for this institute. To my next question.
But Mr. Yarajina, counsel according to the petition. And Mr. SMP.
I am for 1, 2, and
Education for the rest
3,
of
Lordship,
103.
and 5 also. District level committee.
1, 2, 3, and 5. Also her MSD just formed from some for the respondent. The state government, the secondary education, by letter number AAC 23 /2022 /75. 18/02/2022 accorded approval of amalgamation of Asimia High School, earlier known as Asimia Title Madrasa, and Asimia High School A, erstwhile Asimia Senior Madrasa, with Asimia Higher Secondary School at Bager Sangonj, BAGERSANGON, Kanai Bazar, District, Karimganj. Under the provision of Shiksha Kshetra, scheme of Shiksha Kshetra relating to merger and amalgamation of different schools. Comes with the office memorandum number ASC .48/2016/64, dated 03/08/2021. Pursuant to the same, the Director of Pursuant to such approval, Director of Secondary Education Assam by in the education block of Pattakandi. Where is that order? Which means director's order? Pursuant to the same, the Director of Secondary Education Assam by the order number DSC /GIS /CC /16/2021 /119 dated 27/05/2022. Received the necessary order regarding the amalgamation of say Asimia High School within bracket Asimia Technical Madrasa and Asimia High School within bracket Asimia Senior Madrasa with the Asimia High Secondary School. With certain terms and conditions, amongst others, that the movable and immovable property of said Asimia High School within bracket Asimia Technical Madrasa shall be vested in the name of the base school, that is Asimia High Secondary School. Petitioner submitted.
Milord is a Wakaf Parisalana Samiti Milord. Petitioner is the Milord.
Petitioner is Asimganj Wakaf
Parisalana
Parisalana
Samiti,
Committee,
represented by its Mutawali Milord.
represented by its Mutawali, namely Abu Muhammad Sufyan.
My lord.
It is submitted by him. It is submitted by the petitioner that land measuring 4.5 bighas. What is the specific
Milord,
provision? Have you notified the land
Milord, the
schedule of the land?
Milord, the schedule is a very old Milord. I have not annexed Milord. I have just translated it today, Milord. The
Do you
schedule-
have? Do you have?
Yes, Milord. The
Do you have? If you have, just tell us. It will be revenue record, right?
my lord.
So
My lord may be pleased to take up this. Here is entire thing has been given. Milord. Schedule 1 and Schedule 2 will be recorded. 1972, my lord may be pleased to find in the last page. Before the last page is the Schedule 1 and Schedule 2. My lord.
these all entire area
Yes,
consists of.
yes, Milord, what has happened, Milord, altogether 37 Wakafi, Milord, those person who has donated this land is 37 numbers, Milord. They have created this Wakaf property by donating this portion of land in the name of this Milord Wakaf.
4.5 bighas in Likiba.
Mal.
4 bigha, 8 kathas, 14 chataks of land.
Two part, Milord.
Comprising in two parts under 1, 2, 3, 4, 5, 6 to लिख दीजिएगा, हाँ? Under patta number 6 to 81/10 number NO लिखिएगा. Zawaid Ali, ZAWAID Ali. Ali को separately लिखिएगा. Tab number 28 2 लिखिएगा. 6285 by 14. Number Mahmoud Ali, dash 39/44/47, Dag. 6292/21. Number Abdul Wazid, dash 43. Dag. 6294/23. Number Arjid Ali, dash 40. Dag. 6295/24. Number Arjumia, dash 49. And Dag. 6296/25. Number Habiz Mia, M capital Mia, dash 48. Dag. 6297/26. Number Arsad Ali, 41. Dag. 6298/27. Number Etim Ali, dash 42. Dag. 6299/28. Number Arjumia, dash 46/50. Dag. And 6300/29. Number Arjumia, 45. Dag. Bounded by the house of Arfiz Ali in the north, Asimganj Bazar Ghat Road in the south, PWD Road in the east, and Railway Pond in the west. Petitioner submitted it. The said 4 acres, 8 kathas, 14 chatak as a walk of property over which the
Single
Asimia Senior Madrasa
mine was established, my lord.
was established. Petitioner is agree since by said terms and condition number 9, the director of the respondents in the secondary education department directed that the immovable property, said immovable walk of property of Asimia High School in Bracket A, erstwhile Asimia Senior Madrasa, oversight walk of property shall now be merged with the amalgamated, shall be merged and vested in the name of the base school, namely Asimia High Secondary School, stating that the respondent authorities have no such power and jurisdiction to take over such walk of property in the guise of amalgamating said Asimia High School A, erstwhile Asimia Senior Madrasa. Hence this repetition. The respondent authorities placed before the court that as numbers of every persons agree with such amalgamation and merger of educational institutions under the Shiksha Kshetra scheme have approached the court against such amalgamation and merger. It has constituted an amalgamation/merger re-verification committee by an order 10/09/2022 issued by the Secretary Government of Assam in the Department of School Education by order number E.225754/1 to re-verify such amalgamation and mergers of educational institutions under the Shiksha Kshetra scheme. The said extract letters came issued under the office memorandum dated 03/08/2021 at clause 19, as well as in the order, impugn order dated 27/05/2022 issued by the Director of Secondary Education Assam, amalgamating Asimia High School, Astral Asimia Federal Madrasa, and Asimia High School, Astral Asimia Senior Madrasa, which Asimia High Secondary School. At clause 10, provided that any dispute to the office memorandum as well as the existing government rule, procedure, etc., shall be followed. The office memorandum dated 03/08/2021 at clause 19. The office memorandum relating to 6 chapter clause 19 is clarified that for any disputes arising after the order of amalgamation, the aggrieved institution of the public may appeal before the government in the secondary or elementary education department as the case may be. In view of the after really learned counsel for the parties and for the reasons noted above, the petitioner is directed to approach the Secretary of Department of School in Secondary Education with regard to their grievances, its grievances regarding the taking over the Waqf property of Asimia Senior Madrasa by way of such order of amalgamation by the order dated such and such noted. Such and such shall be filed along with the certified copy of this order on or before 13/03/2023.
Along with a copy of the repetition lawsuit.
Along with a copy of this petition into the annexes appended thereto, as well as the relevant land documents.
Yes, I'll annex all
On the basis of which to establishing their case that the said Asimia Senior Madrasa existed in a Waqf property. In the event of filing such and such, after giving an opportunity and on due verification of the records, including the revenue authorities
Yes, Your Lord.
of the district of Karimganj.
Yes.
Deputy Commissioner of Recruitment shall pass a reason order within a period of 60 days from the date of receipt of such order.
My lord, may I humbly pray, my lord, as this property has not yet been acquired.
That is,
My lord,
Will not interfere anything.
My lord, kindly appreciate, my lord, this is our religious and constitutional rights, my lord.
Just take it.
My lord.
The petitioner submitted accordingly. That such Waqf property is according to the religious rights of the Mutawali. Well, concerned Mutawali.
Only I submit, my lord, that till the appeal is decided, my lord, that property they may not.
That new committee that has been constituted,
My lord.
they're not taking over any property.
My lord. My lord.
That is why the government have reconstituted a committee for re-verification.
yes.
Right? Now getting after all such report, in many cases, it has changed.
My lord. Even my lord,
Whatever the
some-
order of amalgamation was issued by the government,
Cancel
the
those.
government have also of their own has
Cancel
verified
those
and
amount.
passed necessary.
Yes, yes. Highly obliged.
For the time being, Mr. We are keeping this.
Yes,
the
yes,
order we passed.
Lord, I will also furnish the original copy of the deed, my lord.
That will be very important for us.
My lord, I will furnish, my lord.
Because otherwise, you need to clear that land documents before the concerned authority.
Exactly. Highly obliged, my lord.
Item number 12.
Yeah, Your Lordship. The case of the petitioner is, my lord, the petitioner is the headmaster cum secretary of Christopher High School, my lord. It's a Hindi speaking school, my lord.
Just
My lord. Was established in the 2005, my lord. Subsequently, the school is recognized and granted financial benefits, my lord, which is in page number 11, my lord, annexure 1.
Yes, then what happened?
Yes, my lord. After the recognition, my lord, the staff, teaching staff and non-teaching staffs was, my lord, approved in page number 12, my lord, annexure 2.
Then
Yes, my lord. In the year 2021, my lord, the SMC, my lord, took a resolution, and some of the teachers, my lord, donated some money, my lord, for the development of the school.
then
My lord, subsequently, my lord, what happened, one of the teacher, namely Rituraj Sohan, my lord, respondent number 5, my lord, he got another job and resigned the school, resigned from this school, my lord, and joined another school, my lord. But after resignation, my lord, resignation duly accepted by the authority, and after resignation, my lord, he demanded rupees 2 lakhs from the petitioner, my lord. And my lord, this matter was informed to the authority, my lord, and subsequently, my lord, one application was submitted before the SP, my lord, but no any action has been taken, my lord. But our simple prayer, my lord, simple direction, my lord, to respondent number 1 to 4, my lord, to look into the matter, my lord.
we will read the judgment of the Honorable Apex Court, full bench judgment. Where Justice Gogoi is also present. That is, go to that full bench judgment. If an affair is lodged, not registered, and thereafter inform the superintendent of police concerned, even there is no action, what is to be done? The constitution bench judgment of the Honorable Apex Court. Go through that and then you make a submission. Procedure is there, whether you'll approach a read court or not. Will not say anything. Go through that judgment and tell us on Friday morning.
Oh, bless fine.
One more. Yes, Mr. Mullah.
My lord. Sir, this is the matter, my lord. The petitioner before your lordship is the headmaster of Zoleshwar Girls High School, my lord. And this school, my lord, has been accredited by the NIOS, National Institute of Open Schooling, my lord. They have, my lord, selected this school as a study center. Now, as per norms, my lord, the head or the principal of the institution is to be coordinator. But here, my lord, one retired headmaster, my lord, who retired in the year 2019, he has been, my lord, appointed as coordinator, my lord. And ID, user ID, password, everything is being used in his name, my lord. And despite representation submitted to them and MC resolution also forwarded them for taking necessary action, and no action is being taken till that, my lord. An exam is scheduled to be held with effect from 16th of March, my lord. Now it's a huge responsibility by the headmaster, my lord. MOU, my lord, that is clarified. MOU page 26, my lord, kindly see, my lord.
That period is already over, 3 years period.
Yes. No, that is
Please come to page number 25.
still running, my lord.
How come? Where is the extension? Where is the extension?
Still running, my lord,
You cannot
because
say that unless you cannot be running, not running, maybe that illegal running.
Yes.
You are given only 3 years period from 2019, 2019, 20, 20, 21, 21, 22. That period is over. You cannot, beyond that, you cannot continue. You are running by of your own or somewhere, something had happened. Where is that approval? By the
approval,
NIOS.
approval, my
See,
lord,
NIOS has granted you only 3 years period to run this open school.
my lord.
Then Above that, that period is over. Unless you establish that you are still having that thing, the NIOS has given you the authority after 2022 session. We'll consider, otherwise not.
My lord, the communications, there are communications.
Unless, how will you able to, without such approval, will able to have that session of 2022 and 23? Your period of that open school is already over. The academic session 21-2022.
My lord, the exams is scheduled to be
We are
held,
not
my
on
lord,
that. And that is whatever you are doing, you have to establish.
and we are receiving communications, my lord.
Receiving communication will not do. Think over.
Then, my lord, let them bring instruction, my lord. If they have terminated this MOU, my lord, we have
Nothing
nothing
like
to say,
that.
my lord.
Why should they? It is your case. Why should they? You have to establish that your school is still having this NIOS open school. Tell us.
The students have filled up their forms for examinations from the center.
Please don't make such submissions. Tell us if you have the recognition or not. After 2021-22. That will be between you and whatever, but not official.
Then, my lord, sometimes may kindly be granted, I will obtain.
Or Mr. Revenue Muller and Council appearing for the petitioner. And Mr. SMT Sisters
For one
Standing
and
Council,
two.
Department of School Education for the restaurant number
And
1
NIOS
and
have
2
their own separate standing council.
and 5, 6, not 5, 6.
Yes.
From the perusal of the annexes appended to this petition, it is seen that the National Institute of Open Schooling, an autonomous institution under Department of School Education and Literacy, Ministry of Human Resources Development, Government of India, grant accreditation to Zaleswar Girls Higher Secondary School, Banyaguri, Bannyazuri, Zaleswar, District Golpara, as a study center of NIOS for a period of 3 years from the academic session 2019-20 by order number F-24/453/2019 NIOS SSM -M SIL /94 dated 20/05/2019. Petitioner is allowed to place such accreditation of the respondent NIS extending St. Zaleswar Girls Higher Secondary School as a study center of NIS after the academic session since 2022 from the academic session 22. Accordingly, say the academic period is already over after the academic session 2021-2020. Petitioner is allowed to file an additional affidavit. Blessing. That is also the school. Still as a study center of NIOS by the authorities of the NIOS from the academic section 2022-2023 and onwards. Till such filing of the additional affidavit. Registry shall leave this matter for motion only after filing such additional affidavit by the petitioner.
Obliged, my
Mr. Botaku, just wait for a few minutes.
May it please the lordship. Lordship, this is an application under 226(3), my lord. My lord, today this case is listed for 4th time. So I want this matter to be taken up. Otherwise, Mr. J. Avedin is left in another court, lordship. And lordship, here I am claiming for the post of assistant professor in roster point 6, whereas the petitioner's claim is against the roster point 32.
Just a
There is no conflict of interest otherwise.
You are respondent number 6.
I am respondent number 6, my lord.
I am 7, your lordship. I have also filed the stay beginning application. It is for your lordship.
Is it here?
Yes,
Take up.
yes. My friends listed, I is listed. My I is not listed, but it's numbered and it's tagged with this matter. Numbered one I listed. Put it to the numbered one I-
Who is for the petitioner?
J. Abedin is for the petitioner.
Assisted by whom? Who is the other colleague? Mr. Nair appears for him.
Initially, he appeared in the writ petition, but now I do not have any idea, my lord.
Where is the
Otherwise-
advertisement?
Yes, my lord. Advertisement, your lordship will find at page 25, my lord.
Is it there in the writ petition?
It is not annexed in the writ petition. Lordship, page 25 of my IA.
It is there in your IA.
Lordship. IA number 289 of 2023,
Yes.
page 25. For the post of assistant professor, Navajyoti College, Kalgasi, assistant professor botany, 2 posts for OBC and 1 for EWS, my lord. Roster point also mentioned here in lordship 32, 6
Just-
and 38.
Just it. So altogether 3 posts.
Altogether 3 posts, my lord.
One is for OBC MOBC.
2 is for OBC and OBC, my lord.
2 is for OBC MOBC, 1 for unreserved EWS,
EWS.
and the other one is for
Altogether 2, my lord. 3, my lord. Roster point 32,
okay.
6 and 38. I am for roster point 6, my lord.
Roster point 32, 6 and 38.
38.
6 stands for OBC MOBC.
6 stands for OBC and OBC. 32 also stands for OBC and OBC, my lord.
And 38,
38 is for EWS.
the claim of the petitioner is against which post?
Roster point 6, my lord, that your lordship will find at page 32, my lord. Page 32 is the declaration of the expert.
Just a minute.
Page 32.
What is it, the writ petition, whether the petitioner has stated that he belongs to OBC MOBC category?
Yes.
In writ petition, he has stated, my lord.
What is that?
Paragraph 2, your lordship.
Paragraph 2, page 5, my lord, of the writ petition.
But there is a judgment of this court. Mammals only within the district of, within the Borak Valley only, not beyond that. There's a recognition because, as you know, the mammals only from the Borak district, districts. whether it will also come to the district of Nagaon or Huzai, because there is a writ petition. Mr. Bhattakur, are you aware of that division? Yes. You cannot claim unless there's a notification by the state government extending that a limit, that will not come only in the Borakville as for the
Otherwise,
Mr. Dhar. Adhar.
otherwise, my lord, the petitioner's basic claim in the writ petition is to condone the overage.
Yeah, that we have seen, but otherwise this issue has been decided.
And he applied basically in the year 2020, my lord, in terms of advertisement issued in the year 2020 for roster point 32. Subsequently, in the year 2022, on another advertisement issued by the college authority, wherein he unable to apply it because of his overage, my lord. But in the year 2022, lordship, I have applied and I have been selected against roster point 6, my lord. So we do not have any conflict of interest otherwise.
Yes, you pray.
Yes. Lordship, my client has preferred the IA number 482, Your Lordship.
Yes, it is
Yes.
for us.
Yes, Your Lordship. Bitupon Kumar Deka, Your Lordship.
You are for the which post?
I'm for the same post as for roster point 32, Your Lordship. My friend is for roster point 6. I was for roster point 32. But Your Lordship, be that as it may, the writ petition has challenged the impugned speaking order, which is dated 25/5/2022. What has effectively happened, Your Lordship would see the notification dated 8/11/2019, which is at page 22 and 23. Page 22 and 23 of the IA, Your Lordship. I apologize, Your Lordship. It's page 24. I beg your pardon, Lordship. Page 24, annexure A6. My name features at serial number 41 at page 26, Your Lordship. This notification was not put to challenge. That is one ground. The other ground being stipulation of age is a policy decision, Your Lordship, which is laid down, if Your Lordship kindly sees, at annexure A3 at 19 and 20. That policy has also not been challenged. Without challenging the policy, without challenging page 19, Your Lordship, page 19. Page 19, Your Lordship, serial number 2. 38 years as on first day of the year in which the advertisement is issued, with relaxation of 5 years for SC, ST and 3 years for OBC, MOBC and 10 years for PWD candidates. Advertisement must be published in so and so. This policy was not put to challenge. My selection was not put to challenge. I was not arrayed as a party. When this writ petition was moved, both my friend and I were selected. We were not put as parties in the writ petition. And there was an ex parte interim order which was obtained, Your Lordship, without bringing facts on record before this honorable court. In fact, as an illustration, Your Lordship, I had just taken out compilations of a recent advertisement of this Honorable Guwahati High Court on the administrative side, Your Lordship, whereby it has been stated by notification dated 22 February 2023 that online applications are invited from eligible candidates for filling up 11 posts of court manager under jurisdiction of the Guwahati High Court and so and so. The age has also been given, Your Lordship, as 41. Now, if there's a challenge to be made to this notification, the challenge has to be at the root of the notification. The petitioner has not touched all of that and has taken a stay, Your Lordship, by not bringing material facts before this honorable court. That is my only submission. Yes.
Mr. Abdi, yes, sir. Whether the Mr. Dhar is available? Mr. Sisti, is he available? Do you know that judgment of our court that extending the benefit was not there? Male community residing in the district of Huzai and Nagaon. Only if it is within the Borakville districts, they will get that benefit. Say, for example, anyone from the hill districts, they're not supposed to pay income tax. Even if it's an IAS officer. But whenever they come back out of their hill districts, they have to pay. Because law written with the apex code is very clear. That's why we're telling you. There is a judgment by this court with regard to such Maimal community. Because the rules prescribe the Maimal communities of the Barak Valley districts.
Barak Valley.
If the government hasn't extended that to the plain districts or the other districts of the state of Assam, there the benefit cannot be claimed. There was an issue before this court.
Well, to an extent, if I remember, it was, I think, in respect of Maimal community only, but it was restricted to only Barak Valley. It's true.
There is a judgment of this court. I think the Justice Honorable Justice Chalamasar as was then, or Justice Goyal forward, the division of judgment was there. Okay, we get.
But otherwise, as far as the case is concerned,
That we will know. We will see to that. The thing is this let us.
no, the thing is that I have to file the objection. I have informed my friend. The person is.
We clarify.
Yes.
Your Lordship, one judgment.
Lordship in the apex code on SLP is file Lordship. SLP 4672 to 74, 1998 Lordship. In this case, Honorable Court in Bhai order dated Lordship 33, 1999 Lordship held that the fact that the appellant society consists of members belong the Maimal community, the Kasar district is not a dispute. Only that particular portion must be decided by apex code Lordship.
Notification is there.
Notification, Assam government notification is there on the basis of Barak Valley Lordship. On the basis of that notification Lordship, that particular case was done to the Honorable apex court Lordship.
The original Sylhet province.
Lordship.
They are the.
Lordship. The dispute as that Lordship.
The community belongs to OBC.
Lordship.
Right.
Lordship.
There are such many districts. You can see there is a community called Mahto.
Lordship. Lordship.
That's also a decision matter decided by the Honorable Apex. The Mahto community comes from Odisha, Bihar, and West Bengal.
They are now they are treated as OBC in the
exactly only in these three states.
Lordship.
But the rest of the country,
Lordship.
even UP, which is
Lordship.
directly to Bihar,
Lordship.
or in Jharkhand,
Lordship.
they are not OBCs.
Lordship.
They are OBC only in the state of Odisha,
Lordship.
Bihar, and West Bengal.
Lordship.
Because Mahto as a community, they are from this forest dwellers.
Lordship.
So that's why they have been only for these three states.
Lordship.
Apex could have clarified that yes, only these three states, they are the OBCs and not in other states. If they have shifted to Haryana, if they have shifted to Uttar Pradesh, being a neighbor state,
Lordship.
or they have shifted to Jharkhand, wherever, or in Madhya Pradesh, they are not.
I remember doing a case where community.
I don't think so. That's the reason. What is the stand of the WPT? This is the important.
Lordship, that particular case was gone to the apex court regarding rejection of tender Lordship. That particular Maimal community peoples are from the Kasar district, East Kasar district Lordship. Then it was rejected. Then it came before the Honorable Apex Court.
Not exactly Kasar. It has to be Barak Valley.
Barak Valley Lordship. It is
originally
original Lordship.
And regarding this lordship, our High Court judgment is also there, lordship.
No, that's what you want to know,
Lords,
because
lords.
Maimal accepting the.
Only for the Barak Valley, lordship.
Beyond Barak Valley, they are not.
They
accepting.
cannot,
No,
lordship.
there is a decision, that's what we want to know.
Barak origin হলে Barak origin.
It was somehow notified to consult. First of all, 32. No, not in state. Assam no. Only in Korak, not in Assam. Yes, Mr. Avedi, anything to say? Yes, Mr. Roy, you're here.
My lord.
There's a judgment by this court, to my knowledge, because this issue cropped up earlier also. Maimal community that is in Barak Valley is considered to be an OBC,
Yes.
right?
Obviously, yes.
Right. Whether this Maimal in other districts of Assam also considered as a OBC? I think it is, as per the notification, it is only in the Barak Valley
Only in
districts.
Barak Valley.
That issue cropped up. I don't know, it was Honorable Justice Chalamese sir or whoever. Beyond Barak Valley, it will not be there. I think that specific observation is because notification is only in the Barak Valley.
My lord, if my lord gives me some time, my lord, I will apprise the court tomorrow or day after tomorrow. Any day, my lord, it's today only, my lord.
No, that's true. Only for that purpose we know, because here the petitioner is claiming himself to be an OBC.
OBC.
first of all, and he says his address is at Nagaon district, Hojai. Now, as such, Hojai, which is now in the Nagaon,
No,
he or she cannot claim as a belonging to Maimal community as an OBC. Because it is for a notification, it is only in the districts of Barak village, not beyond that. Some decision was there. Yes,
I will find out.
you'll find it out and give it to us.
Minor,
We're not deciding the issue today itself.
minor.
It's only for the.
Minor.
if I faintly remember, if the person originates from Warakbali, I think he will have the right.
Nothing like that. That is the law laid down by the IPS code. These people who are originally Mahato community I'm talking about, when they have migrated to the other states, they're not.
No,
Only
but
they are original Mahatos.
No, but the question of within state has to be there.
Nothing like that. That is why the notification is, the reason specifically is after the partition, when the Barakvili came with the first partition.
Yes.
Barakvili came to the part of the Assam, and later second partition, some of the portions of the Barakvili went to the Pakistan, now Bangladesh. So what happened? Originally, this particular fishing community, they are Muslim community. The fishing community, they were considered at that point of time, which was only one India, and that it was a OBC category. They are from the fishing community. So they are from the fishing community, this Maimal community was considered. So after independence, when the notifications came up, that's why I said, because Maimal community is confined only to the Sylhet provinces of that point of time, and the neighboring districts, part of the Sylhet, now Barak Valley, as you know. So some of the districts, particularly Karimganj, part of few police stations of Karimganj and the part of Bailakandi. So what the government of Assam has done, only with regard to Barak Valley. Once you shift that stand from one district to other, that is why notification remain only with the Barak Valley. To go to the original notification. There are reasons for to go to the assembly debates. I had seen that is the reason I can tell you. For some other purpose of it, and
even I faintly
it was
remember
not
that.
extended beyond that. There is no notification in that regard from the.
So I think that in that notification, what my lord is saying, I faintly remember about that notification, my lord.
No transfer. Question of shifting of these things will not be there. A person from Maimal community may shift to any other thing. They have to stick on that. Once they shift from this community, they will not get that benefit. It was decided by our High Court, I know. That's what I'm thinking. Anyway, here for the time being, what we'll do, we'll vacate this order, and any such appointment to those posts will be subject to the outcome of this petition. Right?
Yes, ma'am.
Heard Mr. Jayave, learned counsel for the petition. Also heard Mr. who is appearing for higher education. Director of the Standing Council Higher Education for testimony numbers 1 and 3. You are appearing for personnel department?
No, and I'm for principal matter.
It has gone for the testimony number 2. Mr. E. Sharma, Land Council for the restaurant number 4. Mr. R. Karim, Land Council for the restaurant number 5. And Mr. M. Sharma, Land Council for the restaurant number 7.
I'm sorry to interrupt, Your Lordship. I'm for response number 6.
You're for restaurant number 6.
Yes.
Then I will be for respondent number 5, my lord.
He's been included earlier. That means
You are for Munnibora or Deka?
My lord,
Munnibora.
Munnibora, restaurant number 5. Okay. I'm Sharma for restaurant number 6. Thank you, Mr.
Yes,
The authorities of Novojyoti College, Kalgosia district, Borpeta. On twenty zero to 2022, issued an advertisement inviting applications for filling up of various posts, including 3 posts of assistant professor of botany. That includes 2 posts for OBC/MOBC in the roster point number 32 and 6, and 1 post for unreserved economically weaker section in the roster point number 38. Petitioner stated that she is a PhD degree holder in botany. Resident of village Sanmaji, Lopoka, Kozai, now district of Astral district Kozai, belongs to Maimal community, recognized as other backward classes. District of Assam. Having the requisite eligibility to apply for the post of assistant professor and advertised inside. Earlier, she approved this code. In Mr. Arvind, where is that order of the code? Application number 4745/2021.
My lord, page 64 to 68, annexure 16.
Weighing condone her overage. Enabling her to appear in the selection for the post of assistant professor for a general category candidate in a college. No, as an OBC candidate in a college. In that regard, the petitioner submitted that on 25/12/2020, there was an advertisement for the post of assistant professor of botany at Novojyoti College, Kalgosia, Borpeta. And she apprehended as she the 42 years old.
My lord, is he.
He
He.
or she.
Is he. Ahmad.
Aman. Son of.
It will be he and his.
Apprehended that his application for the post of assistant professor under OT secretary will not be considered by the respondent. Being overrated. So he submitted as if his upper age limit is not consumed, will be deprived from appearing in such selection process for the post of assistant professor. The court, after considering the matter, by order dated 2309/2021, dispose of said petition number application number 4745/2021 of the petitioner, directing the Principal Secretary Government of Assam in the Higher Education Department to dispose of the application to be submitted by the petitioner for condonation of his overage. If necessary, by giving an opportunity to the petitioner to justify his claim. By the said order dated 2309/2021, the court in the application number such and such also clarified that depending on the order that the principal secretary may pass, further participation of the petitioner in the selection process would be determined. And in the meantime, if any call letter is issued pursuant to the advertisement dated 25/12/2020, in said Conviction College for the post of botanic, the post of assistant professor in botanical technology. The same shall also be issued to the petitioner, but his participation shall be subject to the outcome of the order that the principal secretary may pass. Pursuant to the said order of the board dated such and such, passing the application number such and such, the Commissioner Secretary Government of Assam in the Higher Education Department, right, number AHC.26 of the 2021 of the 271 25/05/2022. The speaking order whereby his prayer for relaxation of overage rejected, stating that the petitioner, serving as a teacher of Damunamuk Higher Secondary School, Hodai, on the date of consideration of this case by the said Commissioner Secretary Higher Education was 44 years 9 months. And is not in a position to apply for government jobs. And his only claim was that as he was doing research for PhD degree, for his PhD degree, for a long period of time, for which he could not apply for job in due course of time. The said authority found that it's not a reasonable ground to condone his overage, as the petitioner is bound to complete the eligibility criteria within a definite period that is known to him. And since the petitioner could not complete his academic qualification within the period, therefore he is not eligible for the post. Since all such government posts have specific eligibility criteria. Being agreed with the said specific, speaking order, the 25/05/2022, passed by the Commissioners of the Government of Assam and the Application Department. Persons of the order dated such and such passing the application of Assam. The petitioner filed present petition on 1st August 2022. Praying amongst others, with an interim prayer to stay the same speaking order, the 25/05/2022, which is by the Commissioner Secretary, directing the respondents in the higher education department not to finalize the selection process held on 11/04/2022 in respect of assistant professor in OBC of Nobody College, Kalkasi. The court on 31/08/2022, while issuing notice to the respondents in the interim, directed the responding authorities not to finalize the selection process held on 11/04/2022 in respect of assistant professor, within bracket botany, within bracket PVC of Navajyoti College, Calcasiya, Borpeta. The response number 5 and 6 are the selected candidates for the post of assistant professor of botany, the OBC category, advertised on
2022. Annexure 5 of my
for
IA,
which interview was held on 11/04/2022. If some dates are wrong, just correct it, okay?
Yes, yes, yes.
As in said, as in the present process, the response number 5 and 6 were selected for the post of assistant professor of botany in the OBC category of roster point number 32 and 6, right?
Yes.
6 and 32, my lord, respectively.
Mundibora for 6.
For 6, roster point 6.
And I'm
Okay,
for
roster point number 6 and 32 respectively.
yes.
Were not paid parties and also not issued any appointment letter in spite of their selection. Comma. On coming to know about the said interim order, dated such and such, referred interlocutory applications being IAC 3210/2022 and IAC 23/2023 for their implement as per the respondent numbers 5 and 6. They could accordingly by order dated 25/11/2022 must inside IAC 3210/2022 allowed the implement of response number 5 and by order dated 08/02/2023, sorry 2023, first in IAC number 23/23 allowed the response number 6 to be implemented. Both the respondent number 5 and 6 filed respective interlocutory applications being IAC 5157 of the 2022, IAC 289 of the 2023, and 482 IAC numbers 2482 of the 2023. For modification, alteration, and vacation of the interim order, expert interim order, dated 31/08/2022, whereby the court passed an order directing the respondents not to finalize the selection process for the post of assistant professor of botany, OBC, Navajyoti College, Calcasiya, in terms of the interview held on 11/04. The response number 5 and 6 contended that the authorities concerned rejected the claim of the petitioner for condonation of the overheads. Speaking order dated 25/05/2020. Order. The claim of the petitioner was for the post of assistant professor botany in UBC With regard to the advertise issued by the University College, Calcasiya, Kolkata on 25/12/2020. Petitioner having challenged the advertisement dated 20/02/2022, nor he filed any application for the post of assistant professor within bracket botany, the OBC category as advertised on such and such. And as such, it is also submitted by respondent numbers 5 and 6 that unless the overage of the petitioner is condoned or relaxed as per the relevant rules, the petitioner is not entitled to participate in the selection process as he has already crossed the overage limit, upper age limit for any such public post in the state of Assam. Next week. The respondent number 5 and 6 further submitted that the impugned speaking order dated 25/5/2022 by the state government in the higher education department rejecting to condone / relax the overage limit of the upper age limit of the petition to any such public post is still in force until date. The court have not interfered with the said finding of the authorities in the higher education department. For the aforesaid reasons, the respondent submitted that the order dated such and such
31/8/2020
needs to be modified. Unavailable needs to be altered. Yes, now tell us, Mr. Karim and Mr. Salma, where is the proceeding pending? Whether it is with the Director of Higher Education or Director of Higher Education has given approval.
My Lord, Director of Higher Education had already issued a letter to the principal of every college lordship to participate all the selected candidate in a ceremonial distribution of the
That's different.
appointment letter.
Thing is this, whether appointment letters can be issued only when the Director of Higher Education gives the approval to the decision of the governing body of the particular college approving the selection. Yes. Now, whereas the governing body of Navojyoti College has given its approval regarding selection of the respondent number 5 and 6 as an assistant professors.
Yes.
The roster point number 6 and 32 or not.
Yes.
My Lord.
Whether are you aware or not?
Yes.
Mr. Tawilder,
It is.
you don't have the instruction. Then you keep better not say anything. Yes, from college.
Already my the resolution already set to the Director of Higher Education
Yes.
for their
Do
appointment.
you have any instruction or anything? Can you give it to us?
My lord, it is for
Your Lordship, it is.
Whatever is the give it to us. Mr. P. Samal, Learned Counsel appearing for the respondent number 4, Navojyoti College, Calcasiya. Apprise the court that the principal of Navojyoti College, Calcasiya, by communication slip. The memo number NC/5/DHC/15-16/1700 and same number, last of only 171. Both dated 28/04/2022. Submitted the proposal before the Director of Higher Education Assam for appointment of the respondent number 6 as well as respondent number 5 as assistant professors in the Department of Botany, the OBC/MOBC category at Nobodhiti College, Calcutta. On being selected and recommended by the selection committee for the same post, advertised on please do the otherwise. Referring to the letter of the Director of Education Assam, right number DHC/CE/49/2021/PT/5, that is 09/02/2022. From the above, it can be seen that presently the proposal for approval section 5 or section 7 to Director 2010 rules, some provincialized. 5(1), 5(2) side. Under section 2005 Rule 5(1). 452.
5(7), I think.
5(2) and 5(7). And rule 7. They submitted that provincialized college is presently pending before the Director of Higher Education Assam for its necessary consideration and to its necessary approval and issue consequent appointment order, approval and appointment order to the respondent list 5 and 6 against the post of assistant professor OBC category, roster form number 6 and 32. 32 and 6.
6 and 32.
Respectively. Is also submitted as the order dated such and such passed earlier by this court in such and such is in force. Director of Education Assam not yet passed any order with regard to such information of the authorities of the Nobodhiti College regarding the respondent numbers 5 and 6 who have been selected by the concerned selection committee of Nobodhiti College for the post of assistant professors in the member of the same secretary at post of person to be advertisement 20/02/20. After hearing the counsel for the purpose and considering the address of the matter, the order dated such and such to the extent of such and such it's modified. Clarifying that any such approval and appointment of the respondent number 5 and 6 as an assistant professor of botany in the OBC category number 6 and 32. The Navjyoti College, Kalgasya. Percent of the selection in the academic 2002. Shall be subject to the outcome. The petitioner self-proclaimed submit the representation before the Director of Higher Education is signed. Along with a certified copy. So, individual on 30, we make it 30, 3003 2020. Of the necessary. It's a process. So, fully in accordance with law. Right. With the photocopy filling.
Oblige, Your Lordship.
The prosecutor, in view of the orders passed today, the connected application number 5157/2022. Decide. Cancel. Data take 289048. Individual. It a photo for
Oblige, Your Lordship.
Yes, Mr. Bottom.
This is a review petition, Your Lordship, directed, Your Lordship. In fact, by way of the present petition,
Communication. The principal of the Navjyoti College, Kalgasya, dated 28/04/2020, placed by Mr. P. Sharma, the council for the adjustment number such and such. Report be kept as a part of it. Yes.
Lordship, we are praying for review of the order at page 71, Your Lordship. Your Lordships, by this order, Your Lordship directed the authorities to implement the order dated 17/5/2021 passed by the Deputy Commissioner, Your Lordship, Collector, District Magistrate, Your Lordship, in this case number 81 of 2017, Your Lordship. And it was disposed of at the motion stage itself, Your Lordship, without all.
6/9/2020. Yes.
Lordship, 6/9/2021. Your Lordship may kindly come to page 72, Your Lordship, the operative part, considering the entire aspect of the matter, and as agreed upon by the parties, this writ petition is disposed of at the motion stage itself, directing the respondents, more particularly the Superintendent of Police South Salman Mankasar, Hati Singh Mari, respondent number 3, and the Assistant Settlement Officer Mankasar, respondent number 5, to comply with the order dated 17/5/2021, passed by the District Magistrate South Salmara Mankasar, Hati Singh Mari, in this case number so and so forthwith. If in the meanwhile same has not been complied with, and if there is no other legal impediment created in meanwhile on compliance of the same, and to submit the compliance report before the district magistrate so and so on or before 29/2021. Now, if Your Lordship comes to the order dated 17/5/2021, that is at page 63, Your Lordship. This is the order, Your Lordship. 9/12/2020, both the parties appeared with their so and so. So Mankasar, the CDPO Mankasar project, upon hearing the parties evident that the disputed road is the only public foot road from so and so existing 56 number Angonbari Center at the middle Jarko, and second party illegally obstructed the road which was running since last 8 years over the dark number so and so at Revenue Village so and so under Mankasar Circle. If further appears that first party and all other resident concerned locality have got documentary right, easementary right over the said road under section 147 CRS. During the course of hearing, second party agreed the existing of the said road and voluntarily assured to remove the obstruction from the said road, keeping 10 feet breach from High Madrasa Road to 56 number Anganbari Center at Middle. This is Your Lordship. Then SP South Salmar Mankasar and ASO Mankasar ensure removal of obstruction on the disputed land, Your Lordship. Now we challenge this by way of a criminal revision, Your Lordship, before the Honorable Learned Your Lordship, Session Judge, Your Lordship. That is at page 65. Second paragraph, Your Lordship will get the reference to the order dated
The learned advocate for the petitioner vehemently submitted that this court by an order dated 28 September 2020 directed both parties to appear for the learned court concerned, and according to petitioner has approached the court. But the court, defying all canons of law by order dated 17/5/2001, showing that case recorder received on so and so, taking notice of the report of so and so, and child development project dispose of the proceeding in excess of right conferred so and so, with direction to second party to remove the obstruction. Now, your lordship, then your lordship, page 63, upon perusal of the report, prima facie it appears that impugn order is passed without adhering to the norms of law as directed by this court by dated 28 September 2020, having found prima facie case against the opposite party in passing the impugn order. I am of the view that it is a fit case to admit the revision petition under the garb of section so and so, and in the interest of justice, the operation of the impugn order is stayed until further order. Now, your lordship, this fact was not before this honorable court, your lordship, when this honorable court took up the matter, your lordship, on that day, your lordship. Your lordship, otherwise, this is a statutory, your lordship, under the statute, we have preferred the criminal revision petition, your lordship, and that is proceeding at that point of time, your lordship. Now, my prayer, your lordship, will be, your lordship, to allow that proceeding to culminate or to go into its logical end, your lordship. And since this order is there, your lordship.
Yes, Mr. Das.
Lordship,
This is not in the writ petition.
Lordship, first of all, Lordship, we have not concealed the fact, Lordship. In fact, we did not get any intimation with in respect of the passing of the order of 28/7. Lordship, after passing of this order 6/9/21, when we approached the district magistrate for compliance of the same, thereafter, Lordship, the present review petitioner presented a copy before the district magistrate. Then we came to know about this order, Lordship, and immediately we participated in the revision petition. But we have not concealed at all, Lordship.
Since they have participated, your lordship, that proceeding may be allowed to be completed.
And one more thing, Lordship, in the order dated 6/9/21 at page 72, that the operative portion, there is a condition put by this honorable court. If I may read, Lordship.
If there is no any
legal impediment created, since there is a legal impediment as of now that is on record, Lordship, then automatically this order will not be a bar on that, with my limited understanding, Lordship.
Still, your lordship, if it remains, your lordship, learned session judge will not be inclined to take up the matter, your lordship. That's the problem.
That is what is happening.
And that is what is happening, in fact, your lordship. Since they have already participated, your lordship, to that extent, your lordship can pass the order, your lordship, modify the order.
But Mr. As Portato Council appearing for the review petition.
One and two, sir.
3, 4, 5, 6,
3 to
and
9.
9.
The respondent numbers 1 and 2 as petitioners. While the petition under section 133 of the CRPC 1973, taking its case number 81/2007, before the district magistrate. Waiting for removal of obstruction caused by the present review petitioners slash respondent numbers 8 to 13.
from a road measuring about 400 feet wide inland and flowing total 12 feet much over the lands covered by the numbers 240, 252, 253, 254, and 255. Revenue village Wadanga J H O W B N G Ward 2 Mankasa Circle, District South Sumara, Mankasa. Passing near the residence of the present petitioner number Abdul Ghani. Testimony number 18 and application number. On 09/12/2020, the present review petitions agreed before the Lani District Magistrate about the existence of the said road and also assured to remove the obstruction from the said road, keeping 10 feet weight from HM Road 256 number Angarwadi Center at Middle Wadanga via the Sijun House within 15 days. Effect from 9/12/2020. By order date 17/05/2021, the District Magistrate South Salmara in said this case number 81 of 2017 directed to present review petitioners to remove the obstruction from the said road within 15 days. From District Magistrate in exercising the power under section 133, 144, and 1476 directed to present review petitions. Further directing the Superintendent of Police South Salmara and the Assistant Settlement Officer Manpacha Revenue Circle South Salmara to ensure such removal of obstruction from the disputed road and to report compliance before the said authority. Directing those authorities to take necessary steps for removal of obstruction from the road if not done by the present review petitions. As the said order dated 17/05/2021 passed in this case number 81 of 2017 was not complied with. The present opposite party numbers 1 and 2 refer the connected rate petition in WPC number 4360/2021. Was others for removing the obstruction from the public part of the road from HM Road to existing 56 Anganwadi Center at such and such. In compliance of said order dated 17/05/2021 passed by the Lani District Magistrate South Salmara in this case number 81 of 2017. And to direct The present review petitioner slash respondent numbers 8 to 13 say the application number such and such. Voluntarily remove the obstruction from the said public parts. The court, after considering the matter by the order dated 06/09/2021, dispose of said application number 4863 of 2021. Referred by opposite parties number 1 and 2. With the observation that is number 70 to the set. Documentation. Realization. Mr. Waterpool Council appearing for the review petition is submitted. That after the said order dated 17/05/2021, passed in this case number such and such. Passed by 11 case taken such option manner in this case number such and such. They preferred a criminal revision petition before the learned session judge brief. Doing criminal division number 05/2020. And the learned session judge, after hearing the arguments of both the parties, 24/09/2020, by judgment dated 28/09/2020, criminal division number 11, right?
Lordship,
11 or 20.
28/7. Order.
By the criminal division 11/20, preferred criminal division. Petition being criminal division number, criminal division petition, okay, criminal division number 11 of the 2020 session judge. By order to the 28/07/2021. Admitted the said petition and state the operation of the order dated 17/05/2021, passed in 17/5 or enter procedure 17/05/2021, passed in said in this case number such and such. Until further order, accordingly call for the records case in original by issuing notice to the opposite parties for full and final hearing. Fixing 20/08/2021 for hearing. Mr. Waterpool, can you tell us when Steps was taken by you.
What steps the commission first?
It is placed before the court that though by order 0609/2021, first insert application number 4360 of 2021, though it was directed, categorically directed that directing the superintendent of police South Salmara manufacturer Hatchimari, the assistant settlement officer manufacturer, to comply with the order dated 17/05/25/21 passed by the district South Salmara Hatchimari in this case number 81 of 2017. If in the meanwhile the same was not complied with, and if there is no other legal impediment created in the meanwhile, it's the same. But in view of the such direction, the learned session judge Dhupri is not in a position to proceed with the said criminal division number 11 of the 2021 presently pending before it, with regard to said proceeding of this case number 5, wherein the London district magistrate on such and such party 17/5/21 petitions opposite party number such and such an application. After hearing the land council for the verses and considering and test the matter, it is clarified that since the learned session judge to brief by order dated 28/07/2021 have already admitted the revision petition, criminal revision number 11 of 2021, relating to say this case number such and such, in the London district magistrate such and such was the order of 17/05. It may proceed with the same revision petition and to come to a final conclusion by issuing necessary order. As the court, the order dated 06/09/2021 passed in the categorically observed. If there is no other legal created in the venue in compliance with the said order 17/05/2021 passed in this case number 81 of 2017 by the London district magistrate South Salmara.
Lordship, one clarification, this present revision petition is renumbered as 5 of 22 before the learned sessions as South Salmara at Manchester.
It is got to be, it is stated at the bar. The said criminal division petition number such and such has now been re-registered as criminal division petition number 5 of 2022 before the learned district and learned session judge South Salmara. We have to rise.
Yes.
I mean, only one aspect of the matter, item number 51. This relates to that medical student. So after taking admission, he could not, my lord, continue. That your lordship knows, my lord. And he is mentally disturbed. So matter has to be this way, that was sorted. Urgency is required. I forgot to mention in the morning. Next week, my lord, Shankar Dev was supposed to file an affidavit because his mark sheets are also not available.
Any affidavit has been filed?
Nothing has been filed. I'll inform them, my lord, but
Mr.
let it
Sisti,
come next week.
Mr. Chaliha or who is appearing for Sankadev? Mr.
B. Gogoi was there.
B. Gogoi.
No, Shankar Dev.
Is he available today?
Yes, Lordship.
It's 2 minutes. We have 5 more minutes. We'll see if possible.
But that boy is mentally disturbed. My lord. This way, that way, if the matter is settled.
Please take your seats. Let's see. Thank you. Notaries are by the government of India or by state of Assam?
State of Assam.
In your writ petition, it is government of India?
No, Secretary Education Department, my lord. Principal Health Secretary Health Department. Director Health Department.
No, see.
Huh? Respondent number 1 was not required.
No, what do you want to?
Something different.
Because notary government of India, not the government of India is not giving, is not appointing any notary.
I got the brief someday.
Notary, see the below, the seal, round seal.
Registration number, etc. is there.
The central government is also appointing.
Is there? Huh? Asana. Huh? It is there.
There is also provision for notary appointment of notary by government of India. Central government.
Lordship. Yeah, our High Court also there also.
No, that's what normally what happens, notary by the state only.
Lordship.
But did not notice that even there are notaries appointed by the
4 and 5 are there here, Lordship. 4 and 5 are there, Lordship.
Central government.
Lordship.
What is the procedure? Same procedure.
Same procedure, Lordship.
Who is the authority?
Authority is the law, Ministry of Law and Justice.
তুমি নহয় বি গগৈ
কি কৈছে না না এটা কেসটো কৰা নাই মই জাস্ট কথাটো কৈছো অলপ
I have seen only one newspaper attend. After 18 years, he passes MBA. He was in jail, MBBS.
That's true. That's, I think it's from Assam only. Is it from Assam?
No, I think not from Assam,
No,
Karnataka.
in fact, a few months back, there was a publication in newspaper.
Yes.
Someone passed a master degree from jail. When they was,
Master degree they pass, but MBBS, my lord, I have
this
seen
is
after
MBBS.
18 years.
Mr. Gogoi, this is that with regard to
Medical admission.
Medical admission means that he was mentally retarded for a time
Yes.
and he recovered.
Well, I have got the information from the university. They have stated that well, this is a DME who will have to take a call.
So
Because-
let the
yes.
DME take it, my lord.
Chalia is not here. Anyway, you are also looking
Yes,
after it,
yes.
so you can do it itself. No problem.
My lord.
File the affidavit.
Yes, my lord, I will do that.
Let it come
Or
next
whomever
week, my
it may
lord.
be, whether it is for clarify from the stand from the university. number
Lordship.
one. First stand.
Lordship.
The second
Because
from the.
University, it will not be there because he did not appear in exam.
Yes. Or merely taking admission will not, my lord, make him a, my lord, student under the
Clarify
university.
because Mr. Chalia said it is the domain of the Shankardev University regarding the admission of that. So first clarify your step.
Lordship. No,
Then-
Lordship may record that, my lord. I have got a specific instruction. I will have the instruction for DM regarding, my lord, subsequent admission. Whether he can be admitted now. That can be recorded, my lord.
Mr. V. Gogoi, preparing for the implicit respondent number 6, sorry, 4, 5 and 6. Submitted. That regarding the admission of the petitioner on specific instruction of the respondent number 5 and 6 in the Shankardev, Shankardev University of Health Science. Submitted that Shankardev University of Health Sciences have nothing to do with the admission of the petitioner in the MBBS first year course after his recovery from mental illness. And it is only the Director of Medical Education who is required to consider the case of the petitioner for subsequent information.
What do you need? What's up?
How does admission in the MBBS course?
2015 or 2010 with 10 years with the first school.
In view of safety, specific instruction of Shankardev University of Health Sciences, respondents in the Shankardev. The Director of Medical Education Assam is directed to file a detailed affidavit in this matter, clarifying the stand of the government in the health department of the state regarding the admission of the petitioner in the first year MBBS course after his recovery from mental illness. Such affidavit shall be filed by DME Assam respondent number 2 on or before 4th of April 2023. Thereafter, the petitioner shall file his reply, if any, on or before 21st of April, placed on 27th April.
Otherwise, my lord, classes have already started. So midterm, my lord, otherwise,
Not
this year at least.
See, it happens.
Yes, I understand.
Whether in the next year it can be considered.
They 27th.
Yes. First of all, they will submit their affidavit on or before 4th of April. Thereafter, you file your reply by 21st, if any.
For admission hearing, my lord,
They will
27.
come.
I will be, my lord, even devoted to mention it. In this case.
Sure, sure.
Deeply obliged.
Your Lordship, extremely sorry for mentioning item number 47, Your Lordship. Your Lordship, in this matter, on the last occasion also, the matter was listed by order, but it was not reached, Your Lordship. Matter is about the termination of the candidature of the petitioner who was selected for the post of subject teacher in higher secondary school, Your Lordship. Without assigning any reason, his candidature was terminated. So interim is there, but Your Lordship, urgency.
Respondents have filed affidavit.
No, Your Lordship. Only instruction was sought for Your Lordship.
Find out what is there. At least get the records, the results will be there. If not there, we have it on. 29th.
May I please?
Apply.
Item number 36, there is urgency, there is a violation of the order passed by the honorable court, contempt petition. Till now, that it is not implemented. Can it be? Under the secondary education? Can it be next week, so that the yellow may take up the matter?
May I
File
please,
it.
Your Lordship.